Everybody be seated, please. Good morning, folks. Thanks for being back here this morning. At this point in time, now I'm going to instruct you on the law. Again, you'll be allowed to keep these your instructions. You don't need to make any notes unless we find a typo or some mistake that we need to fix. Again, what I would ask is that you read along with me as I go through them so that I can be certain that everyone's been through there in their entirety on at least one occasion. Members of the jury, you have heard all the evidence, and it's now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: the capital felony was committed for pecuniary gain, and 2, the capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family, friends, and community of Daniel Markel. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Daniel Markel's death. However, you may not consider this evidence as an aggravating factor. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that aggravating factor does exist. A finding that an aggravated factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding, as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor, and that the aggravating factor is sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1, the first-degree murder was committed while Sigfredo Garcia was under the influence of extreme mental or emotional disturbance. 2, Sigfredo Garcia was an accomplice in the first-degree murder committed by another person, and his participation was relatively minor. 3, Sigfredo Garcia acted under extreme duress or under the substantial domination of another person. 4, the existence of any other factors in Sigfredo Garcia's character, background, or life, or the circumstance of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh the mitigating circumstance that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I've said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. And your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision, if to impose a sentence of death, must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. Please also rely on the instructions I gave you previously in the first phase of this proceeding trial. And if you need copies of that, just let us know. We will get you a copy of that. Let's give them the verdict form. Everybody have a verdict form? Let's look at it. It is a little confusing. We'll make sure you understand. So step one, we the jury find as follows as the aggravating factor. Remember, the state is alleged two aggravating factors. Either the capital felony was committed for pecuniary gain, or the capital felony was cold calculated, premeditated. You would check whether you unanimously find that the state proved beyond a reasonable doubt this aggravating factor. As to each of the aggravating factors, you would make that determination. If you find that the state has proven no aggravating factors, in other words, have proven neither of the two, then your job is completed. Your foreperson should date and sign the verdict form, and you do not need to move forward. If you find that at least one aggravating factor has been proven beyond a reasonable doubt, then you would go to step two. There you say, we the jury find as follows as to the sufficiency of the aggravators. The state proved beyond a reasonable doubt that the aggravating factors are sufficient to warrant the sentence of death, or the state did not prove that. Again, you would check your option there. That's unanimously proven by the jury. If you find the state did not prove that the aggravating factors are sufficient, you would date, sign the verdict form. Your job would be completed at that point in time. You don't need to go forward. If you find that the aggravating factors are sufficient, then you would go to step three, similar determination. You decide what you, in weighing the aggravating factors and mitigating circumstances, the state proved beyond a reasonable doubt that the aggravating factors outweigh the mitigating circumstances, or the state did not prove that. You would check that option. If you determine they did unanimously, then you would go to step four. If you find they did not, you would date and sign the verdict form. Your job would be completed. And then step four, we the jury unanimously find the state proved beyond a reasonable doubt that the appropriate sentence is death, or one or more jurors find the appropriate sentence is life imprisonment without the possibility of parole. Obviously, the first option has to be unanimous. The second option does not have to be unanimous, but you would check whichever you have determined be dated and signed by the foreperson. I know that's a little bit confusing, but it's a 4-step process. The state has to prevail on each of the steps for you to move to the next step. At this point in time, the attorneys will be allowed to make their concluding remarks. The state will go first, the defendant will follow. There is no rebuttal argument, so there are just 2 arguments. We'll start with the state of Florida.